Hi, everyone. Happy, I guess, afternoon. Welcome to the legal update series for Maryland. Thank you for joining us. We have a lot to cover, so we're going to jump in. My name is Noura Rafati. I'm a community associations attorney at Lurch, Early and Brewer in Bethesda, Maryland, and one of today's presenters. As a little bit of background, this year I had the absolute pleasure of being a member of the Maryland Legislative Action Committee, better known as the Maryland LAC, and also co-chairing the Maryland Legislative Committee as well. So hopefully a familiar face to some of you, if not most of you.
Good afternoon. My name is Jeremy Tucker. I am the co-chair of the Community Association Practice Group here at Lurch, Early and Brewer. As Nora mentioned, we have a lot to discuss this year, going over the bills that were adopted this year. As we'll discuss as we go through, and I'll share my PowerPoint presentation that and Nora and I will share and discuss the legislation. This year was a somewhat unusual year for the Maryland General Assembly. A number of bills were adopted, which is in itself unusual, related to community associations. I don't know if it's troubling, but potentially problematic is that a number of these bills, especially the first one or two that we're going to discuss, in our opinion, were drafted in such a way that it can lead to confusion. While we tried to address some of those, tried to head off some of that confusion, the bill still seemed to move forward. And I'll be able to give a little bit more insight to inside baseball about that as we go through. And so when we discuss these bills, we will be giving our best recommendations of how to potentially address it. Obviously, we want to discuss it if we are not counsel to your associations, to please discuss it with counsel to your associations as to what they recommend, how to address some of the language and what the bills mean beyond what obviously the language states. Some of the wording used is inconsistent with other statutes within the Condominium Act, the HOA Act, and cooperative. So it brings in new terminology that we haven't seen before. And that terminology is defined, and it's the only definitions and some of the terminology are found in other totally unrelated laws that are clearly not applicable here. But with that, and that gives us something to talk about. And so let's get started. What I would say is if you have questions, what we would like to try to do is answer as many of the questions after each statute, that every bill that we discuss. If you could please put your questions in the chat, that would be most helpful. And we will get to those as we're going forward. I will not be able to see the chat since I'll be sharing my screen, but Nora will be reviewing the chat. We'll ask the questions. So after each bill, we'll try to answer questions related to that bill. And then at the end, we'll bring back this screen, and if people can raise their hands, then we will be able to answer any questions sort of in person, if that's okay. Okay, great. With that, we will, and thank you all for joining today. We really appreciate it, I should say. And thank you for the chapter for hosting this. All right, there are a number of bills that or changes in law that we're going to discuss today. The first one is the election bill that law that we will discuss, which is part of SB 758. And then we will discuss the second component of that bill, which deals with books and records. We'll then discuss the modifications to the existing reserve laws, and try to explain that to the best of our ability. Then discuss the family child care home bill, solar panel bill, Prince George's County CCOC bill, the accessory dwelling unit, ADUs, requiring sensitive information, and the city of, just for information for anybody who is a board member or has properties that they manage in the city of Gaithersburg. We'll just make a quick statement about that. Before I get into any of the bills, I just want to say one that did not pass, just so we're very clear. There's been a lot of confusion, and we've seen a lot of emails. The insurance deductible under the Maryland Condominium Act that you can pass through to a unit owner where the damage originates, it was $10,000. That there was a bill to increase that to $25,000. That bill did not pass. It did not make it out of committee, so that is not law. We have seen a lot of emails and confusion. I think ChatGPT, if you type it in ChatGPT, it seems to say that it passed, but it did not pass. So that $25,000 deductible bill. And if you don't know what if I'm talking about, great, then don't worry about it. But if you do know what I'm talking about, that bill did not pass. We're not going to discuss it any further, but I just wanted to head off any confusion that may exist, since we've seen so many of our managers that we work with email us thinking that the bill passed, and that is an unfortunate confusion. Okay, let's get into what did pass. SB 758, dealing with elections. Just a little bit of background. This bill came out of the Montgomery County delegation. The genesis of this bill was a group of disgruntled homeowners, and if they're on the call, I apologize, but this is not my understanding, believe that, and not one of my clients, believe that the elections that were in their community or other communities were biased, were not handled properly, that inspectors of election had conflicts of interest, that there was all kinds of problems. And that when I spoke to both the head of the chair of the committee and the legislator who was introducing the bill, I asked for examples, and there were none that was coming. It was just this: we get lots of complaints about these things, and we want to adopt a bill that does it. And we went over the bill in great depth and tried to explain some of our, not with the intent, but with some of the problems with some of the language. And then, I won't try to figure out why it made it through committee and then why it made it. And once it makes it through committee, it's almost a fait accompli that it will be approved by the Maryland General Assembly. But the bill did make it out of committee and was approved by the Maryland General Assembly with a few modifications to the original proposal. But with respect to the election, most of that remained. So let's get into what it is. The bill requires that elections be conducted by independent parties. There is really no definition of what elections means. So the question has come up: does elections mean the mailing of the notice, the mailing of the proxies, the receiving of the proxies? Does that require independent? And the statute doesn't provide any. But what I view election in this, and when you look at the common definitions, the actual voting, right? The actual voting. And so for me, that's what I'm focused on, and what I believe the statute is intended to address is the actual vote counting. Who's doing the voting, how the administration of the election is handled, the election itself, not the distribution of notices or the receipt of things. But once it's received, how is that handled? Okay. And who's opening the ballots, who's counting the ballots, who's counting the proxies, all of those things. And that's really where I'm focused on. And one of the reasons why is the bill goes into great depth about the inspectors of election. Okay. And so as you all know, that when we have a board election, you are the chair of the meeting, generally speaking, or the membership, depending how your community or if your bylaws require it, that appoint inspectors of election. The roles of the inspectors of election are to oversee or do the vote count of the proxies, the ballots, things like that. For a lot of communities, especially smaller communities, often the management agent, general manager, portfolio manager, community manager, might be the one responsible for opening and counting it, filling out the spreadsheet, and reporting the results of the election. For whatever reason, that was seen to be problematic. I guess one can speculate as to the reasons why that was deemed to be problematic. So this new statute comes up with a definition of that the inspectors of election must be independent and not have a conflict of interest. Okay. Now, a conflict of interest we'll put aside for a second and come back to it. Must be independent. It defines independent as is not a candidate and not management. That's what independent means. So the managers can no longer be the inspectors of election. There is some provision in the statute that says the management company can be the inspectors of election if the association owns the management company or it's a subsidiary of the association. I don't know if that was meant to be if the association employs the manager, but that's not what the statute says. The statute says if if the association, community association owns the management company. I've worked with communities for 21 years. I have worked with all sizes of communities, from the smallest to the biggest in Maryland. And I have not yet seen, when we have a separate management company, with a community association, that is not an employee. So we will see. Maybe it was Columbia Association, maybe Leisure World, we could come up with some arguments, but for 99.9%, it's not, it doesn't seem to be relevant. If somebody has one like that, I'd love to hear it in the chat. That would be great. So what that means is just that when we're appointing inspectors of election, when the president, if you're trying to obtain the inspectors of election before the meeting, or the president is looking for them or takes them at the meeting, we need to make sure that they are independent. So obviously they're not accountable. So that throws them out. I also think, to avoid this conflict of interest language, I also think it's important that they not be a member of, reside within the unit or the lot that the candidate is running in, not a family member of the candidate, those types of things. So what we are recommending is that when we do the appointment of inspectors of election, we ask a couple questions. We ask a question, obviously you'll know that they're not a candidate, right? We would just ask, do you reside or are a family member of any of the candidates? Do you have business relationships with any of the candidates? Are you in business with all those candidates? And just ask the question. If the person lies, the person lies. But we just think it to show that we took these affirmative steps to demonstrate that, because we all, at least I'm very cynical in some ways. And so I presume that there's going to be challenges under this. And what I'm hoping for my clients to do is demonstrate that we took affirmative steps. We actually made the inquiry. We weren't just relying on faith. We showed that we exercised some diligence. And that first initial step will be helpful in defending these cases if they come down. A conflict of interest is not otherwise defined. I think we all know that a conflict of interest is, in a corporate context, is a very specific term, which refers to having material financial interest. If a director has a material financial interest in the transaction that the entity is about to enter into, that's not. I don't believe that's what is intended here, but we don't know. But that's why we're coming up with what we think could be realistic, disqualifying conflicts of interest and things that we would want to do. So let's sort of talk about this in practice. So the meeting happens. We're at the meeting. The vote. It's an in-person meeting, not a virtual meeting for the purpose of this moment. It's an in-person meeting. The ballots have been received. You may have some from electronic, and you may have some paper proxies and allowing voting at the meeting. Okay. So then, in order to count the paper documents, you would appoint an inspectors of election. So generally it's from the floor, or maybe you have them ahead of time if you or your president chair are very well prepared. And if we have that we just confirm that Jeremy Tucker, Laurie Tucker, and Max Tucker are all the inspectors of the election. And they would be just asked for the record, and are you a candidate? Do you reside within any of the unit with any of the candidates? Are you a family member of any of the candidates? Do you have any business transactions or business interests in anything related to any of the candidates? Great, thank you. And Jeremy Tucker, Max Tucker, and Laurie Tucker will be appointed inspectors of election. Perfect. They do the count. They take care of it. The manager can be there to help administer things, but they are the inspectors of the election. The manager is not doing any count. And what I've seen a lot of times is that this is already being done in practice, that certainly in larger communities, the manager is pulling themselves out of it and allowing the inspectors of election to do the work and just answering questions. If the meeting is a virtual meeting, okay, then there are options that you can do with when the vote is closed. So could you close the vote ahead of time and then have the inspectors of election appointed and counted right then, some after the meeting? Do you have the vote extended afterwards? So at that meeting that's virtual, you'll have to appoint the inspectors of election and decide when the vote count is going to occur and how and where it's going to. Um, in order to, the owners have the right to reject an inspector of election by a 25% vote of all eligible members can vote to, which is a very high bar. And so that is sort of how this little piece will work, is that we're just going to have to make sure that the election is handled by independent people. I forgot one aspect, I apologize. The other part of the conflict of the independence is that inspector of election cannot be electioneering for a candidate. Electioneering is, advocating for the election of. So if they held meetings, gone door to door, spoke out in favor of, the question, of course, is going to be how far does that trickle down to, right? Does that mean that it said, if I'm talking to Nora about Max Tucker's candidacy, and I say to Nora, I think you should vote for Max Tucker, is that electioneering? I don't think so, but we don't know yet. Like, that's what will be potentially flushed out as these come forward. And I know you're like, why is the lawyer not giving us definitive answers? Because this is what the statute says. The statute just says electioneering, doesn't say what the scope of that is, what the limitations of that is. And we are now, as lawyers and plaintiffs' counsel potentially, and owners, are going to be left fighting about what that word means and what the scope of that word means. And that's what happens a lot with statutes that do not have precise language, is that that's a whole industry of the law, is fighting about what the legislature meant when they used the word electioneering, and that's where judges come. And so that's why we know that some of this language is going to be potentially litigated down the road. And so what we can do, what an easy way to avoid some of this is to, and this is at an expense to our clients or expense to the associations, is to move as quickly as we can to electronic voting as the primary means of voting. So using, you can, now the statute specifically says the community association may retain third parties or electronic voting websites. And I don't want to give any sort of, I'm not going to acknowledge any of them, but there are several that are sort of become very prevalent in the industry. These electronic voting websites that will handle the sending of the notice, the sending of the electronic ballots, even potentially the collection of the paper proxies and ballots. All of that can be handled by most of these companies at this point in time. And that way we are effectively outsourcing it to this third party to deal with. Okay. And so that is a very effective technique. That is one of the things that we're really sort of pushing our clients to really start considering, and many of our clients have started moving in that direction. There are ways to sort of enhance using electronic voting. For example, maybe not when you send out the notice of annual meeting with and the electronic voting information, maybe not sending out the proxy, but saying, if you want to vote by paper proxy, you must request one by emailing X. So you're further limiting the number of paper proxies that you're going to get. And you're therefore sort of pushing people to do the electronic voting and not giving them the paper option unless they affirmatively request it, which is actually in compliance with law. Just to repeat that again, is one of the ways to deal with this is to, if you're going to do electronic voting, send out the notice of annual meeting with the electronic voting information and state in the notice, if you wish to vote by paper proxy, you may request one by emailing X, Y, and Z person. Okay, and then one will be provided with the relevant directions. Okay. This law, and so that's the inspectors of election piece, and that is, it may not have a lot of effect, but it's a really interesting way of approaching this from our perspective and how it's going to be really come out to play. And what we just, again, my cynical side, we just worry that this is just going to lead to lots of fights about the process and not the outcome. And even if there was no wrongdoing, now we're going to be tied up in different types of fights about elections. I hope not, and we hope not, but it's very likely that this will be the case.
Jeremy, there is a question in the chat before we move on to the next slide with respect to the inspectors of election. And the question is this a conflict of interest for the inspector My condominium association is handled by the law firm that we use.
That is not a conflict of interest under the statute. Okay, so that would be a third party. Generally speaking, remembering that the association, one would think the same would apply to the management company, but as a law firm, our duty is to the association, not to the board of directors. So we have a affirmative duty of our legal professional duty is to the client, which is the association, not the board of directors. And obviously, if the lawyer does something funky on that, then that's a problem for that lawyer under the professional rules. But right now, as of today, it doesn't violate the statute. Very good question. A few other things about this portion of the statute is that the statute provides that inspectors of election are not personally liable if they act in good faith, which mirrors how directors are viewed. So a director is not personally liable unless they act in bad faith, okay, or quote unquote, breach their fiduciary duty. This is the same type of language that would apply to inspectors of election. So I raised this to the drafter of the statute. I said, but inspectors of election aren't liable. What's the liability? What is the monetary liability for an election? What is the liability to the person who's complaining? This is a volunteer board. There are, what is I'm just putting it there so it's clear that they're not liable. I said, but they're not liable. Anyway, sorry. I got very upset when I was talking to him. As you can see, I still get very upset by this. So, but what it says is it provides a defense to the individual inspectors of election. My view has always been is you don't sue the inspectors of election, you would sue the corporation for overturning the election, not the individuals doing the vote count. But that being said, it's in the statute. We'll need to do that. Interestingly, yes.
No, I was going to say there was another question, but you can go ahead.
One second before I move on. And then this only applies to condominiums and homeowners association, this portion of the statute, not to housing cooperatives. So the election piece, if you are a board member or a manager of a housing cooperative, this does not apply to those entities. This only applies to condominiums and HOAs. Another aspect of this statute is you must make reasonable accommodations for the use of common areas for owners to engage in organizing activities related to the governance of the condominium or their HOA. So this really would impact if we have a clubhouse or we're a condo with a meeting room and they request, we have to make reasonable accommodation for the use of common areas to engage in organizing activities related to the governance of condominiums. Organizing activities, we have to figure out what an organizing activity is, and governance of the condominium. So basically, the easy, quick view is if people want to get together to sort of try to create a new board to take, to get elected, to discuss the governance of the association, we generally have to allow them a place in the common areas to do that. Okay. And I'm not clear that we weren't required to do that in the past. But regardless, that is now in this statute as well, and in another statute, similar language. Okay. So that sort of wraps up this little piece of it. And I know I talked a lot and fast over a lot of things because that's really the breadth of this statute. It was trying to cover so many things on this portion of the statute. Nora, what was the question, please?
There's a question that came in. Is it still required that the election is held open one day after the election? If so, how does this apply? And another question is offering Zoom in lieu of an actual common area a reasonable accommodation? So,
okay. So with respect to the one day after, what the statute for virtual meetings, okay, what the statute actually says is voting can be extended for up to 24 hours after the meeting for those who are present at the virtual meeting to vote, but it doesn't require you to keep it open for 24 hours. So you could technically close it before the meeting. It doesn't require that 24-hour period, but it gives that as an option. So yes, this would affect this in the sense that if you are going to allow voting to continue after the meeting for up to 24 hours by those who are present at the meeting, okay, by those who are present at you can allow for that 24 hours, and then the inspectors of election would have to meet somewhere following that 24-hour period to do the vote count. So that means a practical impact of all of this maybe is that what we've gotten used to of having the voting results at the same night of the meeting or prior to the meeting may not happen with as much frequency as it does. The voting results may not be known for several days after the meeting, and that's okay. But that's just the practical effect. So that's just resetting some people's mindsets that are used to that. We're just going to wait. We're just going to wait to the, we're going to sort of pause the meeting for 3 hours while the vote count is going. Now it may be have to go and do it afterwards, just to be able to make sure that this all works.
Jeremy, a question related to that is, can the vote be held for 24 hours after an in-person annual meeting?
No, no. And so, well, the statute does not authorize that. If a bylaws authorize it, the bylaws may authorize it, but under the statute, there's no authorization. This only applies to virtual. Okay, just like the nomination from the floor, if there's sufficient candidates to fill the positions, you don't need to allow nominations from the floor. That only applies to virtual meetings.
And there was that question about reasonable accommodations,
Oh, thank you.
whether was
No, because that's not common. I mean, if they acquiesce to that and you want to provide them a Zoom link, that's fine. But the common area is not the Zoom. Common area would be real property owned by the association. And so you would have to make a reason. Now, reasonable accommodation in the legal world is a phrase that is used in disability law. Like, we must make a reasonable accommodation to someone with a disability. I raised that too, and he didn't seem to mind and I said, I don't know what, all right, we'll have to figure out what reasonable accommodations in this context mean. So, thank you for the new law and the new legal fees that are be able to be determined as what a reasonable accommodation is. But that is where the statute, so we do have to allow it. So if we have that group of owners that wants to get together and sort of find new candidates to take over the board or discuss their concern, I would like to meet, I'd like to reserve this room to discuss the meeting, what's going on with the board of directors and organize a petition to, we have to allow that. But we get to ask why they're doing it, because it has to be engaging in organizing activities related to the governance. Now, they could say organizing activities related to the governance if they got the statute clear, but we get to ask what the purpose that they're seeking to use the room and evaluate it, whether that falls under the statute. Often, if they wanted to use the room, we may not ask, but now we can ask.
And there was a follow-up question saying, if you have a hybrid meeting, whether that 24-hour to submit a ballot can be used.
Only from those who are attending virtually. The statute doesn't address hybrid meetings, but I would say that if the hybrid meeting is such of a meeting that those online are able to participate in the meeting, then we can extend to those people on virtual meetings the same thing to vote that extra 24 hours. Only those people who are attending virtually, not in person. Because they can't obviously be there in person to vote if it's a secret ballot. So that's why it's there. It's not to give them favor. It's that those who are present at the meeting in person can vote by ballot. They can get up and go put it in the ballot box. Those who are virtually can't do that. All right. The other piece of this bill is deals with books and records. And I just want to go through it pretty quickly, but as everybody I'm sure knows, a number of years ago, maybe over a decade at this point in time, the HOA and Condominium and Housing Cooperative Act were all amended to say that if an owner requests financial statements, the association and minutes, the association is affirmatively required to provide them to email, mail, deliver them to the owner instead of having them come inspect those documents. Okay. Normally they were just emailed out, but I guess some communities were charging for the time if somebody wanted to come in to review financial statements instead of just receiving them by mail. So what this law change clarifies, I suppose, is the community association cannot charge a fee to a owner who comes in to examine financial statements, who comes in to review just the financial statement. Okay? And we may not charge a fee to deliver the financial statements by email. Okay, so if we're emailing the financial statements to an owner, we cannot charge a fee for that. So if you were, for example, somebody said, I want to review the financial statements for the last 3 years, and they wanted to come into the management office, and the management company or management agent was charging a fee to coalesce the documents and for the time associated with standing there, we cannot charge that. So this is just clarifies that. And obviously for an emailing, you cannot charge the fee. So my general recommendation would be is if somebody is requesting the financial statements, okay, is if possible, I would just email them to them. So that way you're not, if you're a manager, that way you're not absorbing this cost of loss of time of them coming in and you having to stand there. So I would just, if you get that request, I would just email. Okay. And remember, this only relates to financial statements. It doesn't relate to minutes, and it doesn't relate to the books and records of a community more generally. It's very focused just on financial statements. Apparently, this was very important and it needs to be clarified, and it's now in the statute. So this is the new law. Both aspects of this statute are effective October 1st. Okay. Any questions before I move on to the next bill?
There are two that came in. The
Thank
first
you.
one is, can you charge a fee to the association rather than the homeowner requesting?
That would be under the management contract.
Okay. And then there are a few more. What if they are posted on the association's website and accessible?
Then you can refer them to that.
And then is there a fee for picking up or mailing the financial statements?
Not that you can charge the owner. No, yes, if you're mailing it, yes, this is only by email.
And then one question that goes back to the previous one was with respect to, is the association required to announce the availability of common areas for the reasonable accommodation, or does it need to be provided upon request?
I mean, you're not required to announce. So it really would be provided upon request. I guess if you wanted to say, you know, this space will be made available every other Monday or every other Wednesday for this purpose. If you wish to reserve it for this purpose, please contact management. Sure. If you wanted to do that, I think that would be a fine thing to do, but you're not required to do that. My general feeling is, you know, do it upon request, and if somebody requests it.
And someone wrote, please discuss proxy votes, but I'm not sure how it's relevant to the new legislation. So I don't have much more on that. Is there anything on the proxy votes?
So there's nothing that really changes affects the proxy voting. Proxy voting would be handled, you know, with a directed proxy. Remember, in order to vote in an election of a board of directors under proxy, it has to be a directed proxy. So the proxy holder has to direct the proxy. The proxy giver has to direct the proxy holder how to vote. So generally, it's a separate ballot portion. That will be counted the same by these inspectors of election. This doesn't alter that responsibility. You know, depending on the county that you're in, how the proxies are handled when they're open can change. So Montgomery County, for example, in Maryland, has very specific ways that proxies need to be handled. Most other counties do not. But so just important to make sure you know where your community is and the proxy handling and form that is required, depending on the local laws at this point in time.
We're good to go. I don't see anything else in the chat.
Okay, good. Sorry, that was the longest of the bills. We'll sort of move on a little bit more quickly, but that was the most intense of the bills, I think. Then HB 292, this is the reserve bill. As you know, a number of years ago, Maryland General Assembly, first for Prince George's County, then Montgomery County, then statewide, mandated that all community associations, state of Maryland, obtain a reserve study every 5 years, and that they fund reserves in their budget based on the reserve study, most recent reserve study. Some confusion happened, you know, with respect to some of the things and somehow it played out. And so this was an attempt by some to provide clarification or try to modify the statute a little bit to provide some clarification as to some of the issues. So I'll just go through the highlights of it. Okay. The association must be funding the amount recommended in the most recent reserve study, updated reserve study, and deposit the funds in the reserve account on or before the last day of each fiscal year. So What this means is we have the reserve study that says we're supposed to be reserving $50,000 this year. That money must be hit the account by December 30. Well, if you're by the last day of the fiscal year. So theoretically, you don't need to be depositing it every month as you're collecting assessments. As let's say the assessment is $100 a month, and $70 goes to operating, $30 goes to reserves. Normally what would happen is the $70 goes to the operating account, $30 goes to reserves. This gives, I suppose, some discretion of when to transfer the money into the reserves, provided it is done by the end of the fiscal year. I've been trying to explore possibilities of when this, how this would happen, but I think the clearest one in my mind comes, let's say we have for HOAs in particular, we have a very large snowstorm or a series of snowstorms, a very bad winter, and our snow removal budget is $50,000, but we end up spending $300,000 on snow removal. We clearly don't have them, and we don't have operating contingencies, so we clearly don't have the cash flow to pay for that snow removal expense. We've budgeted 50, and if we don't have the $150 discretionary out of operating, because we're a balanced budget, we're pretty lean. So we would, in that scenario, we would use what was earmarked for reserves from that collection to pay for this. It doesn't mean pay for the snow removal, provided that the total amount that was supposed to be placed in reserves is done so by the end of the fiscal year. So you would have months to collect that money that needed to be what needed to be based, that $100,000 needed to be put into reserves. And so you'd have the year to do that. And if you were able to do that by shifting operating expenses, potentially increasing assessments mid-year through an amendment to the budget, as long as you're able to accumulate that reserves by the end of the year, you'll meet this requirement of the statute. I'll leave it to the managers who are more, boots on the ground with dealing with the month-to-month cash flow issues about how this will really impact, if this will impact day to day or not, and how you go about recommending to the boards, and how the treasurers, if they're on the call, how they, look at transferring funds from account to account. Just with an eye on, it has to be done by the end of the fiscal year, and that's what the auditor is going to look at. So moving on, if the reserve study is an initial, under the previous law, if it was an initial reserve study, that new study, the reserve study that you got was an initial reserve study, you had 3 years to fund it. They've increased that now to 5 years. So if you take over and it's a new community, this is the initial reserve study, and the reserves are the previous reserve study that was done by the declarant was totally inadequate, and all of a sudden it says you need, instead of the $500,000 you should have in reserves at this point, you need $1 million in reserves. You now have 5 years to make up that delta instead of the 3 years that was previous. But this is only applying to the initial reserve study. Dealing with what I think was some of the the idea that it was unclear how we were going to be approaching funding the reserves, and there was no clear document that was prepared on how to fund the reserves other than the reserve study. What is now required is what's called a funding plan. So in consultation with the reserve specialist, board of directors must create a funding plan to determine how to fund reserves, which must use one of the following methodologies. The component method, the cash flow method, the baseline funding method, the threshold cash flow method, or any other funding method consistent with general accepted accounting. Really, we're going to have to work with our reserve study specialists to create these funding. I hope the reserve study specialists are going to be good. Obviously, if you have a very strong treasurer that has accounting background, that will be very helpful. But I do have some communities that we work with that have had funding plans for years. And this will just be sort of a codification of that type of approach, is that, we really lay out how we're approaching it. There's a methodology, where the money's, how we're evaluating things. In developing the funding plan, we must prioritize health, safety, and well-being of the occupants, ensure the structural integrity such as roof replacements and maintaining structural systems, essential functions such as plumbing, sewer, heating, cooling, electrical, and any other essential or critical purposes as determined by the governing body. So what this means is the funding plan must prioritize the bones of the building, the structures, the balconies, the pipes, the things that keep the building functioning and upright, I suppose. And those are and running. That's what this is. What is not prioritized would be, hallway renovation, lobby renovation, tennis court repaving, those other uses of reserve funds that aren't prioritized under the funding plan. Okay, I want to be very clear. What I'm talking about is a funding plan, how we're going to fund things. This is not a limitation on expenditures. We got this a lot, is can we spend money on using reserves that is inconsistent with our reserve study? For example, our reserve study says, we have to the parking lots have 10 years left. And we're looking at the parking lots, there's a bunch of potholes, they are cracking, there's all kinds of things and we need to do them, we believe we need to do them now. You still can do that, even though the projected useful life may be wrong. Remember, a reserve study is an estimate based on 1 or 2 inspections by the reserve study specialist at a moment in time, based on what they observe at a moment in time, and then extrapolating that based on projections. So yes, there could be expenditures that deviate, but we must return to the funding plan to make up that delta. And maybe it requires when the 5 years over, you need to get a new reserve study, and that reserve study will be altered and change the funding plan because you've sort of gone out of order. So it's important to just remember we're talking about funding and not necessarily expending, but expending money has implications on future funding. Okay, so they fit together, but there are a little bit different. And for those of us who've been around for a while, this is a great portion of the law. Okay, so historically, if a community ran out of operating funds and didn't have enough money to pay their bills, what were they supposed to do? Okay. So what often happened is they would take from reserve funds. Now, reserve funds for the most part is restricted income, right? It's restricted money, can only be used for certain purposes under the bylaws. Okay, you look at the bylaws to see what reserve funds. Sometimes it could be used for contingencies, but most of the time it's allocated and restricted to repair and replacement of community facilities, structural components, common elements, common areas. Okay. So when we would borrow from reserves for sort of an impermissible purpose, i.e. paying for operating expenses, the auditors and legal counsel will generally require those funds to be repaid into reserves. So you take out, for my snow removal example, you take out money from reserves to pay for the snow removal. Okay. Well, always that money had to be repaid. Now, there was no law that says you could do that, and no law said that you couldn't do that. Now we have a law that says we can do that. So what this new law says is reserve may be used for other purposes. So operating, for example, provided it is repaid to the reserve fund with 5 years after use. So I'm using my snow removal example. If we had to take money from reserves to pay for snow removal because we don't have sufficient funds, those funds must be repaid within 5 years to the reserve fund. Okay. So that means that future budgets are going to have to reflect, in addition to the normal reserve allocation for over that up to 5 year span, refunding that $100,000 for snowplow. So $20,000 a year for the refund. So a line item in the budget would be reserve refund. And so you would have to do that. So that is, and the auditors are going to be looking for this. And if it's not there, it's going to be an issue that they're going to raise on their audit. So it's just something that we need to make sure is done. And really the problem, I don't see it as a problem for the first year board that following this. The boards change over 5 years, and keeping that line item clear on the budget would make sure that we don't forget. Things get forgotten very quickly. And when we're looking at budgets, we maybe have a new finance committee, a new treasurer, a new manager who may not have the institutional knowledge. And so it's important that that be reflected so we can make sure it's sort of a tickler almost that reminds everybody of what we need to do. Okay. Any questions about this reserve bill?
Yes, there's one that came in that says if the bylaws allowed a board to make a special assessment and borrow funds, can future projects be funded using those methods in a reserve study? Essentially, can an association plan to fund reserves in the future years by a loan or special assessment?
No. I mean, the short answer is you can't, if the reserve study says you're required to contribute X, this statute says the association must be funding the amount recommended in the most recent reserve study or an updated reserve study and deposit funds in the reserve account on or before the last day of the fiscal year. So while there may be a plan that maybe we'll do a special assessment or a reserve study a loan down the road, that doesn't negate the current obligation to fund reserves. Now, if your reserve balance is low and we need to do a balcony project, we need to do a roof replacement, we need to do pipe relining or pipe replacement, and we don't have enough reserves, right? We just other expenses came up. What normally happens is, yes, you're booking this money in reserves, but let's say the elevators break and we also need to replace the elevators. Well, the elevators weren't slotted to be replaced for 7 years, so we had to take money out of reserves to do that, but to fix the elevators or replace the elevators. But at the same time, we need to replace the roof. But we are not going to have enough money to replace the roof and repair the elevators. So then we look at special assessment and loans for that purpose. So if you fund that, if the reserve fund is, if the money from the loan or the special assessment goes into the reserve fund for that project, that can reallocate the funding plan. So that would have to be worked through with the reserve specialist. If you take a $5 million loan and have all that cash hit the reserves at the same time for an allocated project, then the funding plan would change. So if no longer would, if you're using my elevator example, is the elevators weren't slated for replacement in 7 years, but they break at year 2. Well, we're going to fix it on year 2. We're going to get the funding through a special assessment. Now, our funding plan no longer should reflect the 7 years for the elevator. And that we would have to go back and rework the funding plan with the reserve study specialist and even the reserve study to reflect this new change.
When does this new reserve law become effective?
October 1st.
October 1st.
Okay.
Um,
Now, I wanted to talk about the hardship. Is there a question?
it is, but it's related to hardship. So I imagine that you're going to answer it before.
Okay.
Yeah.
So what we just talked about was sort of the administration of the economics of reserves. Okay. And the bookkeeping aspect. Okay. So to reflect some of the economic realities of communities out there, this new aspect of the law is placed. So it's called hardships, right? Okay. The board of directors, by a 2/3 vote of the board, so if we have a 5-member board, 4 members of the board, may determine that the association and its members are experiencing financial hardship that limits the ability to fund reserves that is otherwise required. If the board finds that there is a financial hardship, it may deviate from the reserve funding requirement for a year after making that decision. And then then it can be renewed by the board of directors, again by a supermajority vote, for another fiscal year, so up to 2 years. Okay. What is a financial hardship? What would a member financial hardship be that would allow us to deviate from reserves? What would a member financial? I don't know, honestly. So what we think about is like a large percentage of the population is unemployed. Potentially when COVID hit and people were laid off in mass, if there is but it's not like a financial hardship in this context, I don't think would be if we have owners that are struggling to pay assessments, that they can't afford to live in the community. That is probably not a financial hardship. Okay. If the board makes this determination, so therefore it would have a year or maybe 2 years exception from having to comply with the reserve contribution, the board must make good faith efforts to resolve the financial hardship and resume funding the reserves. And they must maintain a detailed documentation of the efforts and treat the documentation as records of the association that are subject to examination. So let's say, what would be a hardship, a financial hardship for a community association? Well, the obvious one comes to mind is we have a high delinquency rate. We have 20% delinquency, 30% delinquency rate. We can't, and so it's practically impossible that we'll be able to meet the reserve. Remember, again, we're supposed to have contributed by the end of the fiscal year the money that was supposed to be allocated for reserves based on the reserve study and the funding plan by the December 31st of the fiscal year. If we have 20% delinquency, it's almost impossible that we're going to make that financial contribution by the December 31st. So that could be a financial hardship. And I hope everybody understands that way I'm working through that. Well, financial hardship is like, while we can budget for it, we're not going to be able to meet this standard of the association must be funding reserves in the recommended amount and deposit the funds. This isn't just budgeting. This is funding and depositing funds by the end of the fiscal year. Okay? So now we just know that we're not going to be able to do it because there's just no, unless we increase assessments to contemplate that 20%. So everybody's paying way more because we know we're going to have a 20% delinquency. So we've increased assessments. That could be a financial hardship. Okay? Or, we just issued a massive special assessment and we really tap people out. So we give them one, but we have to show good faith efforts. I'm not exactly sure what the good faith efforts in my hypothetical of delinquency rates, I guess, would be showing that we're taking efforts to collect assessments, keeping records of that, reviewing the delinquency reports, reviewing the status reports from the attorneys, trying to work out payment plans, doing things like that, would be an example of trying to address that. Now, obviously, it would be however the board makes a determination of financial hardship. Again, this really is only theoretically supposed to happen for 1 or 2 years, up to 2 years, and then theoretically not happen again for a period of time, though it doesn't preclude that. Conceivably, it doesn't preclude that you could go 1 year renewal, the new determination renewal. But I don't recommend that they do that. And remember, this money is intended to be allocated to pay for these necessary repairs. And if we're not saving for it, it's going to be very difficult to fund it. These are just some of the administrative stuff. All members must be given reasonable notice in advance of the initial renewal hardship determination. And it's supposed to be only taken at a regular meeting of the membership, which this doesn't really make a lot of sense because this is a board vote and boards don't vote at membership meetings. So I'm not yet sure how we're going to reconcile that. Because boards aren't supposed to vote. Membership meeting is a meeting of the members, and the board doesn't convene a meeting during the meeting of the members. The board doesn't vote on a meeting at the meeting of the members. But that's there. Again, October 1st, 2025. Any questions about this one?
No, none in the chat.
Thanks for your patience as we got through these two very longer, more complicated bills. And the rest of the bills are a little bit more short. So thank you for your patience to work through those. Nora?
Yes. Okay, we're going to turn to family child care homes now. So as you may know already, up until now, community associations have been able to prohibit family child care homes by having their governing documents specifically say they're not allowed in the community. This is no longer the case. So under this new legislation that's going to go into effect October 1, community associations can no longer prohibit family child care homes or large family child care homes in the community. Any restriction or prohibition that you already have in your governing documents will not be enforceable moving forward. So a question Jeremy and I have been getting recently is, well, can the association regulate the number of kids in these family child care homes or large family child care homes? And the answer to that is unfortunately no. So the association can't limit the number of children, below the number that's already been authorized by the State Department of Education. What this means, in essence, is that family child care homes are allowed to operate with up to 8 children, and large family child care homes are allowed to operate with at least 9, but not more than 12 children. There is some good news, and that's that there are some regulations still in place that is beneficial to an association. So the first one is that community associations can continue to require that these family child care providers pay on a pro rata basis any increase in insurance costs that's directly attributable to them. The association can impose a fee not more than $50 a year for their use of common elements and common areas. The association can require that the provider notify the association before operating the family child care home, and they're also required to obtain liability insurance. So yes, on the one hand, you're required to allow them, but on the other hand, there are still requirements in place as far as notification of operating and then required insurance and so forth. And again, this is in effect October 1. I don't see any questions in the chat.
So just to be very clear for everybody who may have a prohibition on family daycare homes in their declaration or their membership has approved it, this now overrides that. I
That's
just
right.
want to be very clear. Just this now is the law. It trumps any provision of any document that may prohibit this use.
Yep. I see a question. If you ban all business from homes, would you need to allow family child care homes? Yes. You cannot prohibit family child care homes. Again, family child care homes and large family child care homes are defined as having up to 8 children for a regular family child care home, and then for large family child care homes having between 9 to 12 kids.
And I think it's important to remember that years ago, when they first adopted this statute, family child care homes and home-based businesses
Correct.
were deemed to be residential purposes. So they're not business. They're deemed to be residential purposes. So if, for example, a provision of your documents say units or lots may only be used for housing and no business, no commercial purposes, these would be deemed to be residential purposes. So that's how the Maryland General Assembly got around that provision of governing documents, saying these aren't businesses for the purposes of covenants. They're residential purposes, residential use for the purposes of covenants.
If there is a percentage of child care homes in the documents, such as 10% of association, can't enforce it.
Can't enforce it.
Cannot enforce it. Okay, we have 2 questions that are similar. One that says 55 plus communities are not exempt, and what about in senior living communities?
Excellent question.
Yep.
So, no, so obviously this doesn't exempt 55 and older communities, so it would apply to 55 and older communities. Because, so a 55 and older community says at least one, for the most part, most documents say, at least one person, at least who's attained the age of 55 must occupy every home. And then it may have restrictions on who can occupy it under 55. Some may have 65, but let's just use 55, okay? So using 55 as the number, most of it's an occupancy requirement. This is nothing related to, these children are not occupying the property. They're there for daycare and then leaving, okay? This is not overnight stay. So in a 55 and older community, this use could be there. There very well could be for the day. And then there's a question of whether they can use the common area facilities in a 55 and older community when federal law says that the HOA can prohibit the use of that. I'm not going to opine on that to you all. I would say that if you are working with 55 and older communities, to contact your lawyers and specifically ask, can we prohibit if the unlikely situation where a family child care home opens in a 55 and older community, can the 55 and older community still prohibit the children's use of the community facilities such as the pool, tennis courts, clubhouse? We have our answer, but because it's an argument, I don't want to give that legal advice to you all. I want you to contact your attorneys to make sure you get your advice from them. Okay. But that's the question you want to ask.
Okay, I don't see anything else on here. So we'll move on to solar panels. So the law right now tells us that community associations can't impose unreasonable limitations on an owner who wants to install a solar collector system on his roof or the exterior walls and improvements that are exclusively his. And it says that an unreasonable limitation is something that significantly increases the cost or decreases the efficiency of the solar installation. Unfortunately, as you can tell, this wasn't very precisely defined, and this led, for this reason, to varied interpretations and enforcement issues over the past several years. What is something that significantly increases the cost? What is a significant decrease of efficiency? And there was ambiguity as to what that actually played out into. So this new law does two things. The first thing is that it sets an objective standard that a restriction is unreasonable if it would increase the cost of the solar collector system installation by at least 5% over the projected cost, or it's unreasonable if the restriction would reduce the energy generated by the solar collector system by at least 10% below the projected energy generation of the initially proposed installation. So it's unreasonable if it's increasing the cost more than 5% or decreasing the efficiency by at least 10%. Now, the onus is on the owner who's making this request to show that the association's restriction is unreasonable. And they can do that by providing documentation that's prepared by an independent solar panel design specialist. So the onus would be on the owner to show that the association's restriction is unreasonable in the sense that it's a 5% increase in cost or 10% decrease in efficiency. The second thing this law does is that it also says that community associations can prohibit or regulate the installation of solar collector systems on the common elements or common areas, and otherwise have the ability to regulate its size, number, or placement. So I don't really have big objections to this legislation in the sense that it really was helpful in clarifying the ambiguity that we've been dealing with over the past several years. Jeremy, I'm sure you had to deal with it as well as to what actually constitutes a significant increase and decrease. So that was really the objective of this new legislation.
As you indicate, this took this subjective determination of, significantly increases cost or significantly decreases the energy efficiency, and what that means. That was the old statute. And this creates an objective standard that can be applied. So let's give a good practical example. We have a rule in our community that solar panels can only be on the rear of the roof. Okay. And an owner says, well, I need it on the front side of my roof because I don't get enough light on the back side of my roof. Now there is a standard at which they can apply that to see whether indeed we have to allow it in the front side of the roof. If the solar system, the energy generated by the solar system is at least 10% below the projected energy generation of the front, between the front and the roof, the front and the rear, then we know we have to allow it on the front. So this gives this objective standard in helping evaluate the applications for installation of solar panels. So, if you have communities or you're a board member, you don't have, and you have solar, roofs, townhouse, single families, and you don't have solar panel policies, you should very much consider working with your team to create solar panel policies that certainly reflect this new law. So we're going to be updating all of our solar panel policies for our clients to reflect this new law.
I don't see any questions in the chat, so we'll move on to an update for Prince George's County registration fees. So attention, anyone, if you're out in Prince George's County, condominium, homeowners association, or cooperative, you need to register and re-register with the county's community association registry by January 31st of each year. And you'll also have to pay an annual fee. The fee right now is not known, but the county executive is tasked with setting the annual fee in an amount that's sufficient to fund the cost of establishing and running the administrative hearing process. This is going into effect July 1st. So this is unlike the statutes we've been going over that have an October 1 effective date. This is effective, I guess, in 10 days or so. The registration form that you'll have to fill out is related, will include information that's related to the association's management company, including things like the length of time the management company has been providing services and a list of all of the community associations in Prince George's County that they've worked with. So this is a way for Prince George's County to get a better sense of how many associations are in the county, who's doing the management services, and kind of gauge what they have at the county level there.
The registration is very similar to the one in Montgomery County with the CCOC, except this one requires, again, that the management company disclose all of the associations within Prince George's County that it's managing to help, we presume, to help Prince George's County build their list of communities so they know what's out
there. Okay. There's always in place. Okay. Sorry. I was trying to look at the comments. Okay. This next legislation has to do with accessory dwelling units, also referred to as ADUs. Under this new legislation, community associations can't prohibit or unreasonably restrict the construction and rental of ADUs on lots that have primary single-family detached dwelling units. Stated differently, if I'm an owner with a lot and I have a single-family detached dwelling unit, then I can't be prohibited from adding an ADU on my property. This ADU can't be more than 75% of the size of the primary single-family detached dwelling unit, and it needs to be subordinate to it in terms of its use. By October 1 of 2026, local legislators will need to adopt local laws and standards on the development of these ADUs and give construction standards, that meet public health, safety, and welfare standards, including building codes. So that still hasn't been published in most of the local jurisdictions. The interesting point here for homeowners associations, HOAs, you will have the authority but not the obligation to treat an ADU as a separate lot for purposes of voting and assessments. Again, you may but are not required to treat them separately for purposes of voting and levying assessments against them. One of the things that has come up is whether, if we're supposed to allow them, can we still regulate how they look? Yes, the association's architectural guidelines, if you have them, would still apply. It's just that you cannot prohibit someone who lives on a lot with a single family unit you can't prohibit them from constructing it, but you can set standards as to what it should look like and architectural guidelines that it needs to meet.
So let's talk about the voting piece real quickly. Okay, that assessment piece, because that comes. So as Nora mentioned, we can treat an ADU as a separate lot for the purposes of voting and levying assessments. Okay, so even though our declaration says that how assessments are determined, how voting rights are determined under this statute, arguably we can do it this way. So how would that work in practice? So, and why? Okay. So we have, let's say we just, for ease of numbers, it's 100 lot HOA. Okay, one vote for one lot, one member per lot, so 100. Okay. We have an ADU. Let's say the homes are 2,000 square feet. Somebody they have a big enough backyard, they can build a separate detached ADU, and that's they can go up to 75% of their home. So let's just say they can go up, let's just for ease of use, go up to 1,500 square feet. Okay, so now you could build a 1,500 square feet ADU in your backyard, presumably if you have enough that size of the backyard. As Nora mentioned, the board still has the right to approve what it looks like. Can't reject it, but have architectural control over what it does. So for ease of numbers, we have two structures: primary residential structure, secondary residential structure. Primary residential structure, let's just say, has 5 people living. The secondary residential structure has a household member of, let's just say, 4 people. Now on one lot, we have 9 people. 9 people using the amenities, 9 people living in the community, driving on the roads, going to the pool, using the clubhouse, taking advantage of the association services. 9 instead of the original 5 single family. So 9. So what this statute, I believe, is contemplating that scenario is that, well, if you're going to have 2 separate households living on a lot, because it's up to 75%, which was shockingly high. I mean, in my mind, shockingly high. It's not just creating a separate like apartment in the basement. This is potentially built. If you have a 4,000 square foot home, or 3,500 square foot, this is a sizable secondary structure you could build, lot size permitting. Okay, and so this idea would be is that, well, if the boards wanted to, they could say, well, since you're using more services for the purposes of assessments and voting, there's now 101 lots. The owner of the lot with the ADU and the single family home will be assessed, basically 2 assessment units, and we'll have 2 votes. So that effectively how that. Okay. Again, I'm not aware of any other state, and there maybe California, but I'm not aware of any other state that has adopted such a similar statute before. I could be wrong. So how this will work in practice and whether it ever be invoked, I don't know, but that's the rationale that we've come up with how this would be applied. Any questions?
I see one that had to do with the Prince George's County, but not one related to ADUs. It says, is this registration for associations or management companies?
Well, it's for associations, but if the management company is doing the registration, they have to disclose their information.
That's right. Okay. Yep, we're good to go.
So we're coming down to the end, so thank you, everybody. This one's a pretty simple one. Is we can no longer request, if we were, sensitive information from residents or members as a condition for accessing shared common recreational areas such as reading lounge, game room, playground, swim. Sensitive information is specifically defined as social security number, so we can't ask for somebody's social individual taxpayer ID number. I don't know that we were birth certificate, put a pin on that one. Racial or ethnic origin, I can't ever imagine anybody doing that, but we can't do that. National origin, we can't do that. Obviously, if we start doing that, we're opening ourselves to fair housing questions. And so obviously that citizenship or immigration status, don't do that. Religious or philosophical belief, don't do that. We obviously wouldn't do that to begin with. And medical records. So birth certificates, but you could still, but sensitive information does not include an individual's government issued identification, such as a driver's license. So we're still allowed to passport, driver's ID, things like that. The only time we've ever seen sort of birth certificate type of information requested is sort of dealing with minors, whether they have access to the gym or pool unsupervised. Are they old enough to use the gym? Are they old enough to use the pool when there's been some question? So we'll have to work out other ways to determine that. And obviously medical records we would never sort of request that, in your gym. The only time that would ever sort of come up in my mind would be dealing with gym rules or exercise classes. But we can't ask for that information anymore. And interestingly, I don't know if COVID came back and we had required people to produce COVID test results to remember, we all had to do that to access the community facilities. I don't know how I'm not yet how this would reconcile if we had another outbreak of something. And so I'm not sure how that would work. Whether a test result would be considered a medical record for this purposes. So we will have to wait and see how that, hopefully that'll never happen again, but we'll have to wait and see how that will play out. The last bill, just very quickly, if you are a board member or manage any properties in the city of Gaithersburg, which is located in Montgomery County, they have opted out of what's the Montgomery County Commission on Common Ownership Communities. That means if they are, as of July 1st, any community association within the city of Gaithersburg is no longer subject to what was called 10B of the Montgomery County Code. That means that community association no longer have, those board members no longer have to do mandatory training, register with the county, pay the county fee, or participate or notify regarding the dispute resolution. Just wanted to make sure that everybody who may be within the city of Gaithersburg, just because it is effective next month, and if they haven't heard of it, the city of Gaithersburg has done a pretty good job of explaining that. Okay, thank you all for bearing with us through this. Was obviously when we do this from a lot of, each year for a lot of different places, this is the most intense statutes that we've had to deal with in many, many years of many statutes. So are there any other questions that we can answer regarding these bills? See any hands raised?
No, I don't see any hand raised. I don't see anything in the chat except people saying thank you, but I don't see anything. Oh, Linda has a question. She's raised her hand. Linda, go ahead.
Okay, so where can we get the forms to register for the CCOC's new law, which goes into effect in 10 days? Because your note said we don't know what the fees are going to be, so where do we stand?
So it's this one is registration, not fee. So, and that you have to be registered by, is it December 31st or
January 31st.
January 31st? So the law comes into effect to get people starting to register. So they didn't want to wait till October. So everybody's registering between October 1st and January 31st. So you now have up until January 31st to register. I was good just going on the Prince George's County CCOC website.
Okay, thank you.
Wow.
Okay, we have a question in the chat. Does the voting just apply to vote of board of directors? First bill, or like 7604 potentially, which is a membership vote? Does the voting just apply to vote of the board of directors? Oh, is this for the inspectors of election? I would imagine. Yes. So for the
This only relates to election votes. It doesn't relate to, very good question. Does this relate to a vote regarding amendments? Like if we have a special meeting to adopt amendments, or a special meeting or a meeting to approve a special assessment, right, for membership votes. This only relates to the electors of inspection, and the bill really says elections must be independent. And that really is just limited to the board election.
And then
Thank
Wendy.
you, Wendy, for posting that. Appreciate it.
Okay. I'm trying to see if we have hands. Linda, I see you have a hand up, but I'm not sure if that's the one that you already had up before, or if you have a new question. Okay. Okay. I don't see anything in the chat, and I don't see anything on the screen. Okay, everyone. Well, thank you so much for your time today. We hope that this was a helpful summary of the legislation that was adopted this year. Okay, I'm not seeing anything. All right, Jeremy.
Thank you all for coming. We really appreciate it. And I was just responding to a chat. And thank you. It was helpful. Certainly, if you have any questions, feel free to reach out to us, but really appreciate you taking your time on a Wednesday to learn about community association law. So we really appreciate it. Thank you again. Thank you to CAI for the opportunity as well. Thank you all.
Thank you, everyone. Have a great day.